Hello, everyone. Today we're diving into one of the most significant constitutional case in the Philippines history. Chavez against Gonzales, decided by the Supreme Court on February 18 of 2008. This sits as the explosive interaction of press freedom, political controversy, and the anti-wiretapping law, also known as Republic Act 4200. So, by the end of this video, you'll understand what this case was about, the dramatic facts behind it, the legal issues at stake, the Supreme Court's groundbreaking ruling, and the crucial lessons we all can learn from it. So, let's get started. By the way, I'm Shania Dries S. Villanueva. Excuse me. So, what is Chavez versus Gonzales all about? In essence, this case is about the constitutional battle between freedom of the press and the government attempts to control what the media can report. The case revolves around the infamous Hello Garci tapes, alleged war-taped conversation between the President Gloria Macapagal Arroyo, the then president, and the COMELEC Commissioner Virgilio Garcilano, supposedly discussing the rigging of the 2004 presidential election. When these tapes became public, it created political firestorm. The government, through the Department of Justice Secretary Raul Gonzales and the National Telecommunications Commission, issued warnings threatening media outlets with legal consequences if they continued to air or publish the contents of these tapes. The central question became, can government prevent the media from reporting on matters of public interest by invoking the anti-wiretapping law? Is this a valid restriction or it is an unconstitutional prior restraint on press freedom? Francisco Chavez, a private citizen and former Solicitor General, challenged these government warnings as a violation of constitutional guarantees of freedom of speech, expression, and the press. Let me walk you through the timeline of events that led to this landmark case. June 5 of 2005, Press Secretary Ignacio Buñe told reporters that the opposition was planning to release an audio tape of a wiretape mobile phone conversation between President Arroyo and high-ranking Comelec official. Later that same day, Buñe held a press conference and played two versions of a tape. One he claimed was complete, and another he said was spliced or doctored to make it appear the president was rigging the election. 7th of June 2005, Attorney Alan Pagia, former counsel of deposed President Estrada, released what he claimed was the authentic tape recording. The tapes allegedly include conversation invoking the president, the first gentleman, Commissioner Garciliano, and the late Senator Barbers. Now, here's where things get really interesting. June 8th of 2005, DOJ Raul Gonzales issued a stern warning to reporters. He stated that anyone who had copies of CD, anyone broadcasting it, or anyone publishing its contents could be held liable under Wiretapping Act Republic or the Republic Act 4200. He went further, claiming that possessing or airing these tapes was continuing offense, and the people could be arrested on the spot by anyone with personal. June 9, 2005, Secretary Gonzales doubled down. He ordered the National Bureau of Investigation to go after media organization that had caused the spread, the playing, and the printing of the context of the tape. He specifically mentioned INQ.net, a joint venture between the Philippine Daily Inquirer and the GMA, stating he would invite their editors and managers for what he called tactical interrogation. Think about that phrase, tactical interrogation. Can you imagine the chilling effect those words would have on journalists? June 11, 2005, the NTC issued its own press release warning all radio and television stations that airing the tapes violated the anti-wiretapping law and could result in the suspension revocation or cancellation of their broadcast licenses. June 14, 2005, after a dialogue between the NTC and the kapisan ng mga broadcasters sa Pilipinas, they issued a joint press statement. While the NTC claimed to respect press freedom, the damage was done. The warnings had already created what the Supreme Court would later call a chilling effect on the media. Francisco Chavez that filed a petition directly with the Supreme Court asking the court to nullify these acts as unconstitutional prior restraints on freedom of speech and the press. The Supreme Court had to grapple with several critical constitutional issues. Let me break let me break them down. So, for the first issue, legal standing first. There was a procedural question. There was a procedural question. Did Francisco Chavez even have the right to file this case? After all, he wasn't a member of media. And interestingly, the media organization themselves didn't come forward to challenge these warnings. In fact, they issued a joint statement with the NTC. Second issue, prior restraint, the main constitutional question was whether the press statement and warning issued by the DOJ Secretary and the NTC constitute impermissible prior restraint on freedom of speech and the press. Prior restraint means government censorship before publication or broadcast. Third issue, the application of Republic Act 4200 would airing these tapes actually violate the anti-wiretapping law? Let me give you some context about the Act 4200. The Anti-Wiretapping Act, passed in 1965, makes it unlawful to secretly record private communication without the consent of all parties. It prohibits not just the recording itself, but also the possession, replaying, and dissemination of illegally recorded conversation. But here's the crucial question. Does the fact that broadcasting these tapes might violate a law automatically justify silencing press? Can a government use the threat of prosecution to prevent media from reporting on matters of immense public interest? Issue number 4, content based versus content neutral restriction. The court had to determine whether these warnings were content based restriction, targeting specific subject matter, or content neutral regulation that merely controlled the time, place, or manner of speech. This distinction matter enormously because content-based restrictions are presumed unconstitutional and must pose the clear and present danger. This test, while content-neutral regulation only need to serve a substantial government interest. Issue number 5, print versus broadcast media. Finally, the respondents argue that broadcast media enjoys lesser constitutional protection than print media. So the warning to radio and TV stations should be held to a lower standard. Can broadcast media be treated differently? All of these issues would force the Supreme Court to clarify a fundamental principle about press freedom in the Philippines. And for this section, the Supreme Court decides on February 15 of 2008. The Supreme Court handed down its decision. In a 10-5 vote, the court granted Francisco Chavez petition and struck down the government's warning as unconstitutional. Chief Justice Reynato Puno wrote the majority decision and its masterpiece of constitutional law. Let me walk you through the key holdings. On legal standing, first, the court brushed aside the technical question of standing. Even though Chavez wasn't a journalist and media didn't join his petition, the court said that the transcendental importance to the public or press freedom issues demanded that they address the case on its merit. The court recognized this was about more than one person. It was about fundamental freedoms that affect all of us. On prior restraint, the court found that the warnings issued by the Secretary Gonzales and the NTC absolutely constituted prior restraint. And here's the crucial part. The court rejected the government's argument that these were just informal statements that didn't have legal effect. And the court declared it is sufficient that the press statement were made by respondents while in the exercise of their official functions. In other words, when DOJ secretary or the NTC speaks their official capacity, that's a government act, whether it's formalized in a written order or not. The court noted the obvious power imbalance. The NTC can cancel broadcast licenses, and the DOJ secretary can prosecute people. When officials with that kind of power issued warnings, journalists listen and often fall silent. On the clear and present danger, the court applied the clear and present danger test to these content based restrictions. This test requires the government to provoke what the speech would cause an extremely serious imminent harm that the government had has the right to prevent. And here's where the government's case fell apart. The court found that the respondents failed to prove who actually wiretapped the conversation, how the wiretapping was done, whether airing the tapes would actually violate RA 4200, and what clear and present danger to national security would result from airing the tapes. The court declared not every violation of law will justify straitjacketing the exercise of freedom of speech and of the press. The government must show as substantive evil of extreme seriousness and eminence, not just a potential legal violation. On chilling effect, the Supreme Court, excuse me, the Supreme Court found powerful evidence of chilling effect on the media. After this warning, many media outlets went silent on the issue. The KBP issued that ambivalent joint between statement with the NTC. Francisco Chavez was left alone to fight this battle. And quote about the deafening, the court wrote, this silence on the sidelines on the part of some media practitioner is too deafening to be the subject of misinterpretation. On broadcast media, importantly, the court clarified that while broadcast media may be subject to certain regulatory schemes that don't apply to print media, like licensing requirements and frequency allocation, the clear and present danger test applies equally to all forms of media when dealing with content based restriction. And the court explicitly rejected the notion that broadcast media deserves less constitutional protection when it comes to government censorship. The final ruling, the Supreme Court granted the petition for the certiorari and prohibited it nullified the June 8th and June 11th statement made by Secretary Gonzales and the NTC declaring them unconstitutional prior restraint on freedom of speech and the press. Now, let's talk about what we can learn from this landmark case. These lessons are as relevant today as they are or were in 2008. First lesson: freedom of press is not absolute, but it's fundamental. The court emphasized that press freedom stands on a higher level than substantive economic freedom or other liberties. It's a preferred right in our constitutional system, while not absolute. Any restriction faces a heavy presumption of unconstitutionality. Why is press freedom so crucial? Because without a vigilant press, the mistakes of every administration would go uncorrected and its abuses unexposed. The press is the people's watchdog over government. Second, the government cannot silence criticism through legal threats. This case teach us that government officials cannot use the threat of prosecution to silence reporting on matters of public concern. Even if the media might be violating some law by broadcasting certain material, that doesn't automatically justify censorship. The government must prove a clear and present danger of substantive evil, not just a potential legal violation. So this is a high bar, not and intentionally so. Third lesson: official acts don't need to be formal to violate rights. The court made it clear that prior restraint doesn't only occur through formal orders or written circulars. So when government officials speak in their official capacity, those statements are government acts that can be challenged as constitutional violation. This prevents officials from hiding behind the excuse of just expressing an opinion when they're actually wielding government power. Fourth lesson: the chilling effect is real and dangerous. This case provides a textbook example of chilling effect. When government's actions cause people to self censor out of fear, even without direct prosecution, the court recognized that the mere threat from powerful official can silence the press as effectively as actual censorship. We must be vigilant about recognizing and challenging chilling effect on free expression. Lesson number 5: public interest matters more than technical violation. The court showed us that when matters of enormous public interest are at stake, like allegation of election reaching by the president, the public's right to know can outweigh concern about technical violation of other law. The totality of circumstances matters. We must balance all interests involved, not mechanically apply rules without considering context. Lesson number 6: understanding Republic Act 4200's limit while the anti-wiretapping law serves important privacy interests. This case shows that RA 4200 cannot be used as a weapon to suppress the dissemination of information on matters of vital public concern. The law prohibits the wiretapping itself and the use of such evidence in proceeding, but its application must be balanced against freedom. Lesson number 7: constitutional rights require constant defense. Perhaps the most important lesson in that constitutional rights don't defend themselves. It took Francisco Chavez, a private citizen with no personal media stake, to stand up. Even the media itself seemed cowed into silence. Each generation must actively defend the freedom we cherish. Eternal vigilance really is the price of liberty. Lesson number 8: the role of the courts. Finally, this case demonstrates the vital role of independent judiciary. The Supreme Court didn't just rubber stamp the government's action or hide behind technicalities. It exercised its constitutional duty to check government overreach, even in politically sensitive cases. Chief Justice Spooner wrote, the constitutional imperative for us to strike down unconstitutional acts should always be exercised with care and in light of the distinct facts of each case. But in case where the challenge act are patent innovations of the constitutional of of a constitutionally protected rights, we should be swift in striking them down as nullities per se. A blow too soon struck for freedom is preferred than a blow too late. Excuse me. So, to wrap up, Chavez versus Gonzales stands as a powerful reminder that press freedom is essential to democracy. The Supreme Court made clear that the government cannot use threats and intimidation to silence reporting on matters of public concern, even when invoking legitimate laws like the Anti-Wiretapping Act. The case teaches us that prior restraint on the press faces a heavy presumption of invalidity. Content based restriction must pass the clear and the present danger test. Government officials' statements in their official capacity are government acts, and the chilling effect on free expression is a serious constitutional concern. Public interest in crucial matter can outweigh other legal consideration. Remember, press freedom isn't just about protecting journalists. It is about protecting all of our rights. When the press can freely investigate and report, we all benefit from a more transparent, accountable government. Thank you.